The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. Good morning, everyone. We have three cases for submission. The first case, Jerry Hoffman and Hoffman Innovations, Inc. versus Scott Clark and Real Tuners, LLC will be heard orally. Two other cases will be submitted non-orally, and they are Iowa Supreme Court Attorney Disciplinary Board versus Elites, 21-1799, and In Re Interest of KD and KD Minor Children, 21-1472. So the latter two are submitted, and we're ready for our argument in the first case. Mr. Sease, I think you're up first.
Justice Appellant, may it please the court. As mentioned, my name is Matthew Sease, and I am here representing Scott Clark and Real Tuners. Today, we ask that this court reverse the district court for several reasons, but I'm going to focus on three reasons, particularly in our oral argument, but I am prepared to address any of the issues that are raised in our brief. First, we ask that this court reverse the district court's determination of striking the pleadings of Mr. Clark, including his answer and his counterclaim. Second, we ask that this court reverse the district court and order a new trial based on the improper submission of the facts deemed admitted to the jury, both being read to the jury prior to opening statements and being submitted to the jury through the jury instructions. And third, we ask that this court grant a remitter and/or a new trial on the damages that were awarded in this case. Now, starting with the first issue regarding the striking of the pleadings, I want to start with talking about an issue that was raised by the Court of Appeals that we had brought up in our briefs as to the proper time frame of when we need to make this analysis. It's our position that this court needs to look at that determination of striking the pleadings based on the record that was before it at the time of the third and fourth motions for sanctions and compel that were filed in this, not compel, but contempt or show cause that were filed in this case. And I think that that's with good reason. In this case, particularly at that time, Mr. Clark was acting pro se. And when the district court struck that answer and that counterclaim, that clearly had an effect on Mr. Clark and his prior actions from that day forward. And so I think that that's the only proper time that this court should consider the analysis of whether it was appropriate to strike that answer and that counterclaim. Secondly, within that same argument, we take umbrage with the court granting that discovery sanction in this case. First, it's unclear to me if there is any case in Iowa that has recognized the propriety of striking an answer and a counterclaim regarding non-discovery issues. And what was in this case, what the allegations were a violation of the contempt or the consent order that was entered in this case. There was no allegations at all that any of the statements that were made that were in violation of that consent order in any way prohibited or affected Hoffman or DIY's ability to prosecute their claims. Instead, all of the statements that were being alleged to have occurred in this case that were in violation of the consent order were just that. They were in violation of the consent order. Arguably, they were continued to be defamatory, and they could increase or be evidence that is presented by Hoffman throughout the trial. He could certainly amend his pleadings and include further actions. But there was nothing that occurred at that time that prohibited Hoffman's ability to prosecute this case any further. And if you look of what we asked the court to do is adopt the federal Rule 37 standard for discovery sanctions. And the first one of those factors that we ask that this court consider is the prejudice to the underlying litigation that happened. And that leads to exactly what I was saying, that there was no prejudice to the underlying litigation in this case.
Of the consent order lead to additional disputes that are within the scope of the pleadings?
I think it just leads to what I mentioned, Justice Apple, in that it certainly could increase the amount of damages if there is defamation or libel per se. But as far as discovery itself or prohibiting or hindering Hoffman's ability to present anything at the trial, it just doesn't do that. This was an effective protective order where it just was both sides were just not supposed to comment on the case. Mr. Clark, I think, arguably violated that, but again, it didn't lead to any discovery violations. And this court has repeatedly said in several cases that when a case is filed, the goal is to have it determined on the merits, and that did not happen in this case.
Specifically, do you think the district court should have done in terms of sanction?
That there were options that were aligned with what happened in the first two and what happened after that fact. And I think the proper way to handle this should have been, they all should have been rule to show causes, and they were filed as rule to show causes, and they will all be contempt violations. And under the contempt statute, what is allowable for contempt is fines and potentially jail time. And that's what happened in the later actions. And I think that that is the proper way to do it. I don't know of any case, as I mentioned, that says striking the pleadings is the appropriate remedy for violations of those actions. And then what happened, in my mind, is probably one of the most egregious things that happened at the district court level was the reading of these 100 facts deemed admitted. Yes.
Argument waived, though? I mean, was objection made at the time to that reading?
Was, Your Honor. And it specifically happened, I think, in at least 3 times. Once immediately before either openings or right after openings when preliminary instructions were done. They were specifically read to the jury, and Clark's trial counsel said, Your Honor, I object to the reading of those. So I think that that is the first instance of it. Then when they were submitted as part of the jury instructions and included within or at the jury instruction conference that occurred, Clark's trial counsel again said, I object to the reading of these. The district court has already read or found a directed verdict on behalf of the plaintiff, and there's no basis or reason to do this. And then renewed his argument that it should not have, the pleading should not have been struck in the first place. And then in the post-trial motion, specifically on pages 130 of the third appendix, in the motion for the judgment not withstanding the verdict and or the motion for new trial, he specifically said, I object, it was improper for the court to read these instructions to the jury. So I believe error was preserved, Your Honor, on that all the way through. And what we take umbrage with is 12 or 11 specific facts that were deemed admitted. I don't know if
Objection made to those specific facts, to any of the 100 items?
general objection to all of them.
Waived?
Believe that, I'm not specifically saying that the court should not have read just those 11. Our position is that they should not have read any of them, but here's 11 really bad ones and really point to why this shouldn't have happened. And that's what our argument is, Justice McDermott.
Move to your point 3. What's your number? What's the remitted number that your client asked for? I don't know that I've seen one.
Answer or ask for, and this clearly is a libel per se claim. And so I think then, and what our position is and what my position is that I don't know if they proved any damages, and so then we get to the nominal damages, and I think that the nominal damages under Iowa law is $1. And so I think that...
Right, though. I mean, here's the way I see it. I'm troubled, and I'm going to ask the other side, by the amount of the libel per se verdict. It seems to me that the concept is one of presumed damages, presumed real damage, so that the plaintiff gets a real number on the theory that it's difficult to prove how much you've actually been damaged when these kinds of things are said about you. But it doesn't mean the plaintiff should get an exorbitant number or the jury can just award anything. And so aren't we looking at sort of an in-between position, not $1, but maybe not, $4 million or whatever?
The basis for the alternative relief is of a new trial on this, and that was specifically requested by Mr. Clark's trial counsel, and I think that runs in line with this court's prior precedent in Reese versus O'Malley, and in that case, it was an attorney during a city council meeting made reference to a landowner potentially extorting his client or having the ability to extort him, and that was determined to be libel per se, and the jury awarded $250,000 in that case. This court said that damage was too high and remanded it back down for, I believe, a full new trial on that issue and limited to damages.
Difference between the amount that was awarded to Mr. Hoffman individually and to his company on this point, because there was some evidence that his company didn't have the growth that they had, and there were very limited numbers, at least, that were put in. So is there a difference between those two?
So, Justice Oxley, I think that it's required on both of the personal libel per se and on the business damages. And what was the main point of?
Consider those to be special damages with respect to the entity?
I believe that they are reputational. I don't know if exactly what they are, to be frank. During his direct examination, Mr. Hoffman testified to a basis in which he arrived to $4.5 million. He said, I looked at my prior year's growth, and that was 23%. I didn't experience that growth in 2018 and 2019, and my revenue based on that, it was a loss of $4.5 million. But then during cross-examination, he said, well, I don't really know. I just came up with it. This is what my corporation, how do you put a value to this? And so it started to sound like actual damages, Justice Oxley, but then it went into a reputational damages analysis. And so, and I think that's a key an issue that is before this court and has been decided in that Reese case, which is you cannot have libel damages based on the defamatory acts themselves. And I think if you look at what happened at the district court, you look at what happened in the Court of Appeals opinion, that's what the damages are in this case. They are all based on the defamatory acts that Mr. Clark did, what happened leading up to the trial, and that's it. The damages to show actual damages in this case are lacking almost entirely. And I want to go back to that $4.5 million.
What kind of factual showing could you make in a defamation case? So you have these various defamatory statements. There's quite a few of them, at least, out there. They're being published. We don't know how broadly, I guess, but we know they're being published. Can't one infer from those kind of facts that there've been some kind of damage?
I think you can, Justice Apple, and that's what the Reese case kind of hit on, is that it's not simply enough in libel per se cases to just rely on the defamatory statements. And what you would expect, and what's talked about in the Reese case, is testimony regarding the good reputation or the reputation of the individual or the company before the defamatory statements happen, and then their reputation after it. And so what I envision, Justice Apple, as a hypothetical, is testimony that come in that would say, I am a really great upstanding person in the community. Here's church members or people that walk down the street, everybody says hello to me and shakes my hand. And then after these defamatory statements, people shied the other way. They would spit in my face. They wouldn't interact with me. That's what you would expect. And it wouldn't, I don't believe.
Counsel, don't you sort of have that with the Facebook posts and things like that? I mean, there were clearly people saying very negative things about him afterward, and that evidence was put in, and I'm not sure that there was any contrary evidence put in. Isn't that enough here?
It is enough in this case. There was no evidence to establish what his reputation actually was before or after. There was certainly some online debate about the products that were happening, but I don't believe that there was anything that I would think is sufficient to establish reputational damages for this, for Mr. Clark or Mr. Hoffman personally or his company. And in fact, in Exhibit 118, which was in Appendix 3, page 477, there was one of these defamatory statements that was allegedly sent to Mr. Hoffman's business partner. And it's this email that's a fairly lengthy email, and it was read to the jury. And then during examination, Mr. Hoffman said, yeah, he read that and he didn't care about it. He's still my business partner. If he had left me, that would have been a big problem and I probably would have gone out of business, but he's absolutely still my business partner. I would expect for reputational claims that that individual would have left him, and then that would be a claim for reputational damages. But when there's an admission that these people are reading all of these online comments or actions or podcasts, that they would have some strong problem with his reputation moving forward, and that just did not happen in this case.
New trial would be limited to the amount of damages for the defamation per se, and we leave the judgments for the on the other counts intact.
First, we ask that we go back to the first part, but if it's going to be limited just on the new trial for that, I think what our position is that there was a sufficient basis for the damages award for the breach of contract claim and for the breach of fiduciary duty. We have a problem with the civil extortion claim. I see my time is up, but we have a problem with that as well.
Mr. Katz?
May it please the court. I'm Seth Katz, and I represent the Hoffman plaintiffs, appellees in this case. The nature of this case and the amazing campaign, online campaign, that Mr. Clark and his entity were able to conduct was unlike anything many lawyers and respectfully judges have ever seen. And as far as the research I've done into the case law, that's supported. Justice Christensen noted that Mr. Clark knew exactly what he was doing, and because this was a Facebook campaign, and it wasn't just Facebook, there were other online attacks, Mr. Clark was able to very easily reach hundreds of thousands of people, prospective clients of Hoffman's, actual customers, the public, business partners, and it was just with amazing prowess.
If it had not been for the consent decree, though, you would not have had the pleading struck, right?
If it were not for the consent decree, that's correct.
The argument that Mr. Sease makes is, why the consent decree is a court order. You violate a court order, there are sanctions for that. What is the basis for striking pleadings in response to a consent decree as opposed to a discovery abuse or something that directly prevents you from proving up your lawsuit?
The consent order in this case provided for sanctions, and due to the nature of the online attack, it prevented my clients from having a trial on the merits. It grew the causes of action exponentially because...
I don't follow that. I mean, why couldn't you have just brought all the more violations, the more evidence you have at trial?
About some of the damages that occurred. We only found some of the postings. Some of the postings, we don't know if they existed. They were not produced to us in discovery despite our requests. And in addition to, even if we were able to find all the postings, it's impossible to know all the damages because what about the customers, prospects, business partners that read this horrible stuff and say, I'm just not going to do business with Jerry Hoffman? Some of them...
kind of address that issue as opposed to striking all the pleadings? Why wouldn't the spoliation as a remedy satisfy that as opposed to striking all pleadings and counterclaims?
Respectfully, again, we would have to know everything that was spoliated. But in addition to that, the trial judge entered this order, this discovery order, this consent order. The parties entered it to maintain the status quo, to get to a trial on the merits, to stop the bleeding. And both trial judges and the Court of Appeals noted that due to the nature of this online attack, it stopped the trial judges from being able to control the case. It stopped Hoffman from being able to present all the evidence. And it got to the point finally where, with understandably and with all due respect to the district court judges, they were so frustrated because Clark would not comply and he continued to violate the consent order. It just got to a point where it was, we got to try this case.
I mean, we have a pretty clear body of case law, I think, that says the penalties for contempt are set forth by statute, and it could be jail time or a fine of up to $500, I think is the statutory amount, and that judges are not allowed to go do something different. And it seems like here the district court judge just decided to do something different, maybe out of frustration, that's fine, but I'm not sure that answers the question of whether or not this was the appropriate remedy for violations of this particular order. So can you help me with that? How does this sanction comply with the statute related to contempt?
Striking the pleadings in this case, the answer and counterclaim cites the rule of civil procedure that was relied upon that we believe gives the district court authority to strike a pleading for nonconformance with a discovery order. The nature of the violations we believe are incredibly important because, as the trial judge noted, it wasn't a function of just frustration. It was a function of the intentional behavior, the intentional violations of the order that the trial judge tried repeatedly to curb.
The violations of the consent order were not discovery violations. I understand the district court cited the discovery rules, but as I read the order, it really didn't regulate discovery. It regulated the party's conduct outside of discovery. Is that right?
Respectfully disagree. In our position, it is the order was a discovery order in part, and the violations of the order stopped discovery from being able to proceed in any meaningful way, caused the need for an incredible amount of additional discovery.
Of the order, would you point to as being discovery orders?
The parties are restrained from saying anything else about each other that is negative, anything else about their business. And in the record at the various hearings, the trial judge explained the basis for that is just what I'm suggesting to the court now, to maintain a situation where we can get to a trial on the merits, to stop this bleeding, to stop the need for additional discovery, and to get the case moving to some sort of meaningful resolution. Mr. Clark explained to the trial judges that he knew exactly what he was doing.
Question. There's a timing issue. Mr. Sease, as you heard, said, well, I mean, there were 12 motions total, I think, but the sanctions order was entered after maybe the first 4. That what we ought to be looking at is only the record up until the time of the sanctions order. You heard it. A, what's your response to that? And then B, he also implied that at that point, kind of ratcheting down the contempt remedies was the way to go, including, frankly, incarcerating your client. So A and B, let me know.
Court of Appeals did a thoughtful analysis that I know this court is aware of as to whether it was appropriate to consider the sanction after the 4th motion for sanctions or after all of them collectively. Even if it were the 4th, as the Court of Appeals believed, the sanction of striking the pleadings was appropriate. Mr. Clark was aware of the order that was in place. The trial judge tried to, and did in fact sanction him with attorney's fees, payments into the court registry, threats. We asked that the pleadings be stricken, and he just wasn't moved. And it got to the point where he would get online and say, I'm never going to do what the court says. And so the trial judge repeatedly, both of them said, we don't want to strike the pleadings. We understand it's a serious remedy, but he just left us no choice. As to the first point, Mr. Clark at one point, this is in, I believe, our brief to the Court of Appeals, at one point when it was suggested, Mr. Clark said basically, don't do anything, but please don't incarcerate me because it'll kill my business. And the trial judges tried to do what they could to be reasonable. But ultimately, when he actually was incarcerated, and we believe this is telling, as did the Court of Appeals, Mr. Clark immediately got online. He was in jail for 30 days. He missed Christmas with his family, got online, and he said, that was the best 30 days I ever had. I'm still never going to produce what that judge told me to produce. Nothing would have worked. Nothing worked, and the judges tried. Both of them tried to get his...
Here's kind of in the big picture problem, which is Clark was very defiant, very disrespectful, very dismissive of the authority of the court, and that deserved, merited, warranted the full authority of the court going after him. Did it also warrant your client getting, in essence, kind of an empty net to shoot at in the lawsuit? That's the problem that we're having. In other words, did it also warrant this extraordinary relief that your client got in addition to whatever the court needed to do to enforce its authority?
That benefit, as I'll put it, if I understand the court, wasn't really a benefit. First of all, again, and I'll make this one quick because I know the court has heard me. Our position is that Mr. Clark forced this. It's a function of his own doing. The trial judges were both very cognizant that trials on the merits are preferred. At the same time, the conduct persisted through trial, through today. And so that benefit, that sort of windfall, again, my words, if I understood the court, wasn't really much of a windfall because Mr. Hoffman and his business hasn't really gotten any benefit. It may have changed things at trial a little bit, but Mr. Hoffman still had to prove damages, and he still had to prove that those damages were caused by the appellants.
Damages, you've heard some of the dialogue we had with Mr. Sease. What is your position on libel per se damages? Is it just whatever the jury wants to award, or are there any limits?
Our position is that there are certainly limits, but also in this case, it wasn't quite as the appellants submit. That is,
What are those limits?
have to be within what the evidence shows at trial. It has to be reasonably tied to the loss of business, for example. In this case, my client.
Is not a damage. Normally, we look at loss of profits. Your client has that kind of evidence. They have financials. They have tax returns. They chose not to bring that to trial, right?
Was put in. Some of that evidence was put in terms of revenue, and then upon cross-examination, my client explained that it was a 40% profit.
On that point, wasn't that only as to one customer? Or was it 40% profit as to all customers? In other words,
That wasn't clarified necessarily on cross. My recollection and understanding was it was asked about that specific customer, but I don't know that it was quite phrased that way upon cross. But my client also testified as to numerous other businesses and resellers that he lost. Upon cross, there wasn't a conversation about specific figures. But he testified as to multiple. It wasn't just one, and I believe one of them, as to the one that included actual figures, I believe the name was Motion Raceworks. There are a number of other instances where my client testified we lost other business. There are also a number of instances where on these posts, prospective clients and actual clients, I'm sorry.
the number that he put out for revenues for, I think, 17, 18, and part of 19, or most of 19, was 4.5 million. Is that right? And then the jury awards 4.1. But the 4.5 million is based on revenue. It's sort of tough to sort out maybe how the jury got to 4.1. Can you help us?
The jury, I believe, got to 4.1 because of the incredible nature of what happened here and due to the repeated testimony by Mr. Hoffman that various other entities and customers and prospects left. There was testimony that somebody saw these comments and said, well, that explains why Jerry Hoffman did X, Y, or Z. People were relying on what Scott Clark was saying, and they decided not to do further business with my client.
As I understand the 4.5, that's based on a 20% increase every year. So that would sort of already bake in not only all of the customers that he had, but some new customers too, right? Like a fifth more every year.
I didn't take his testimony as being speculative in that he thought, here is actual dollar figures that he was including. What I think he did was, I think he, in my understanding of the testimony, was that he listed that specific figure with Motion Race Works. He talked about other business that he lost. He talked about his pain and suffering and mental anguish, and explained to the jury that that all went into his calculation as to why he was requesting a 4.5 figure. And then the jury at that point took it over from there.
That his anguish number was part of the million that he got for the personal defamation. Is that, so I had understood that there was 4.5 million that he put in as to business and then another million as to his personal. Is that right? Okay, all right. So the mental anguish part would be the personal part and not the business part. Do I have that right?
Makes sense to me as well. And I think, again, as to the 4.5, he selected a figure based on what he had put into that business to grow it, what was taken from him, the business that he lost, including the actual figures with Motion Race Works and otherwise, and everything else that he saw with his own two eyes that was a result of what Scott Clark did. And
If we determine the damages are excessive and order a new trial on defamation damages, what do we do with the punitive damage award? Can we leave that in place?
punitive damages, if it was going to be left, and I have 20 seconds, I believe the punitive damages is going to have to be tied to a figure that's given as compensatory. It's going to have to be, so perhaps it's stayed as a new trial takes place, but a new trial does nothing but forgive Scott Clark and give him a reward to which he is not entitled, and I'm out of time.
A question, Justice Apple. In the event that we conclude, say hypothetically, that the libel per se damages are too high or excessive, is it your position that you would prefer a remitter to a remand for a new trial?
And that is our preference. We believe that the, yes, that is our preference. We don't believe remitter is appropriate, but yes, we believe a new trial is the essence of injustice for my clients. This is an area of law where, I know the court is aware, this is an area of law where when you're talking about someone's reputation, their name, damages are difficult to quantify precisely and for the many reasons set forth in the Court of Appeals opinion. Judge Christensen's opinion, Judge Reyes's opinion, in our briefs, and the law cited therein, we believe that the damages are appropriate. If they need to be lessened upon remitter, then so be it, but that's all I have. Thank you all.
Thank you, and may it please the court. I want to address Justice McDermott's questions regarding how the jury came up with 4.1 million. I think if you look at the verdict form, what they were doing is ultimately Mr. Hoffman asked for $5.5 million, $1 million for himself and then 4.5 for the corporation. And then what we see if you look at the verdict form, they awarded like $250,000 for extortion, so they took that off of the 4.5 million. They took off $102,000 for the breach of contract claim, and then for the fiduciary duty was around $20,000 or $25,000. And if you add those three damages claims into the defamation per se as it relates to the corporation, then you get back up to the 4.5 million. But that also gets to my point that the damages as a whole were, there was fuzzy math done by Mr. Hoffman to get to that level.
You, again, remitter, you said last time $1. Is there a different number? I don't know that this court would go for $1. Is there a different number that you're asking us for?
As it relates to the libel damages, I don't know if there's anything else in the record to justify anything other than what I'm requesting as nominal damages. I don't think that there was any evidence established by Mr. Clark that was admissible or that could be considered to give us a dollar amount other than that. There were certainly, he had the ability to do that. He talked about he had staff members that were dedicated to this.
Isn't that kind of always the issue? I mean, libel per se, again, damages are kind of a special animal under libel per se. You don't have to prove them up with the same rigor. On the other hand, it isn't just an open door for the jury to award whatever they want to do. Isn't that right?
Kind of is, and it goes back to what Justice Oxley was talking about earlier. Libel and defamation and slander have their own beast, right? There's reputational damages. Those are those presumed damages. But within that, there are also actual damages. And we have that blend here. And what I'm talking about is the actual damages that could have been established. When Mr. Hoffman says, I have 3 employees dedicated to this 24 hours a day, he could have come in and said their salaries are X dollars and I need that, but that didn't happen in this case. When he says I have to work until 2 o'clock in the morning, then my hourly rate is XYZ, that's what these actual damages were worth. And that's what I think is the problem in this case, is that there's this blend of both reputational damages and actual damages that make this really difficult based on the record that was presented to the jury in this case.
Same question that I asked Mr. Katz. If we were to conclude, let's say hypothetically the court didn't accept your arguments for your first and second arguments, and we're just talking about damages, is it your position you prefer remitted to a new trial on let's say the libel per se damages?
Absolutely, I would prefer that. But I don't know what the remitted amount is. I mean, I guess we see in certain cases that involve emotional distress where we look at prior verdicts and we set a high watermark of, and I think that there is a litany of cases that may be $100,000 or $200,000 for emotional distress. And what we typically see at the district court level for that is plaintiff, we're setting the high watermark of emotional distress damages at $200,000 based on prior case law. You can either take that or you can get a new trial and ask for more.
In this new world now where, and this is, at least from my perspective, one of the reasons why I'm interested in this case. So we have a situation where Mr. Clark is not a particularly deserving individual, but what he's done is not uncommon in this day and age. It's something that happens. And people are out there saying all kinds of things on social media. And my concern is if we start having verdicts that are just way, way, way out of line and they're non-dischargeable in bankruptcy, then you're going to have people who, because of something stupid and improper that they did, are never going to be able to dig out of that situation. And that's kind of what I'm concerned about.
Exactly. And I don't know if I have a real good answer for you, Justice Mansfield, that other than what the reputational damages that were established and presented at this case in no way justify the verdict that happened in this case. I don't have anything further. Thank you.
All is submitted. Bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.